Thank you so much to our staff at BPS, and welcome everybody to the second meeting of the Senate Judiciary Committee. We have two bills to hear today. I understand that our presenters are already here and they are ready to get started. So I'm going to go ahead and open up the hearing on Senate Bill 8. We will do 8 first and then 7 due to the presenters' time constraints. And if I could have Judges Marquis and Schreinerdt. I'm not sure if you're both presenting or how you'd like to begin.
Good afternoon, Chair Scheibel. Judge Marquis and I agreed that I would present the bill, and then we're both available for questions, although I do have the time constraint. I have a trial at 1:30, so I really appreciate the committee's ability to hear us first. Thank you. So to Chair Scheibel and members of the committee, for the record, I am Judge Tamitha Schreinerdt from the 2nd Judicial District Court. I serve as a judge in Department 14 in the Family Division. In addition to divorce and custody matters, I oversee all of the minor guardianships in Washoe County. I also serve as a member with Judge Marquis on the Nevada Supreme Court Permanent Guardianship Commission, and the Guardianship Commission is in support of SB 8. An overview of the bill. In 2017, the guardianship statutes were rewritten to separate the adult and the minor guardianships into their own sections. When that occurred, the provisions for transferring and registering a guardianship was left out of the minor guardianship section. So SB 8 remedies this by mirroring the provisions from the adult guardianship statutes and placing them into the minor guardianship statute. In addition, SB 8 clarifies the definition of the child's home state to ensure it conforms with the other child and family statutes, specifically the UCCJEA, which is a law that all states have subscribed to that ensure that only one state at a time is making orders regarding a child. And then finally, SB 8 allows for the appointment of a guardianship in Nevada as long as the child is here and it's in the child's best interest, and even if Nevada is not quite their home state in terms of timing. If you have the bill there, I will just briefly go through each section with a short example. Section 2 is the ability to transfer a Nevada guardianship out of state. This does help with folks who need to move away, who have guardianship. Sometimes it's difficult for them to get a guardianship in the new state while there's still an open case here in Nevada. So with the transfer provision, that will help those guardians. Section 3 allows the transfer of an out-of-state guardianship into Nevada. An example is this, if say some grandparents have had guardianship in California for quite some time, they have a new job here in Reno. This allows them to transfer their case here to Nevada with their court's permission, and then we can set up a case here with, of course, oversight. And we do require oversight and a hearing before granting a Nevada guardianship. Sections 4 and 5 allow the registration of an out-of-state guardianship in Nevada, again with court oversight. This is something that you can do if you have a custody order from another state. You're allowed to register it here, and this allows that to be done in guardianships. This would be in a case where perhaps it doesn't need to transfer, but the state needs to know. For example, we have a lot of cities that are bisected by the border between Nevada and California or other states. A family might live in a different state, but the child go to school in Nevada. So then they can register their guardianship here. Moving on to section 6, that is the clarification of home state. The home state is where a child has lived for 6 months prior to a court order, with a lot of other provisions as well for emergencies. So now the guardianship statutes will conform to that. And then finally, section 7 is the part that allows us to appoint a guardian in a case where Nevada isn't quite the home state. An example of this is if someone moves here over spring break, not spring break, probably summer break more likely, and they need to get the child enrolled into school. We don't want to have to make them wait 6 months to get home state jurisdiction. So long as the child is present and it's in the child's best interest, we would be able to issue the guardianship, again, with court oversight and a hearing. That is my summary. That went a lot faster than I thought it would. I'm certainly here for questions. I know Judge Markey is as well. We both are on the Guardianship Commission, as I mentioned, and we're happy to take some questions. Thank you.
Thank you so much for your presentation. I will kick it off with 2 questions that I have. Your Honor, did you also get a copy of this letter that we received from Mr. Sean McCoy regarding potential conflicts with the UCCJEA?
You know, I'm sorry to say I did not. And did you, Judge Markey?
I did not.
Okay. If I were to send it to you, would you be willing to take a look at it and get back to us on whether there are any conflicts between this law and the UCCJEA?
We would have no issue with that at all.
Okay, I figured as much. And then I just have one other question that pertains to the home state definition on page 4. I noticed on lines 18 and 19 that we have moved from was physically present to live with a parent or a person acting as a parent. I've not seen acting as a parent language used in our statute before. Is this the first time we're using it, or does that have a known legal connotation?
Judge Markey, I will turn to you in the sense that I believe this is taken from the UCCJA, and the language from the UCCJA is just placed into the statute to cover situations such as guardianship. But let me ask if my colleague has any updates on that.
In this I would agree first with my counterpart to the north, but in this context, when they discuss acting as a parent, they are alluding to a guardian who has had a guardianship, perhaps in another state. She talked about California, and has moved with that court's permission to Nevada, but has not yet been here for the 6-month requirement. Here, we're talking about 2 needs: the need to go to school and be able to sign up for school. We don't want for kids to be sitting at home for an additional few months as we wait for that 6 months of jurisdiction. The other issue is being able to put that child on the guardian's health insurance. Now, certainly we have the ability to grant a temporary. The temporary has limited uses. It could be used for emergencies, medical emergencies, but generally we see health insurance will refuse to honor a temporary and need that general guardianship. I also would note that there is an expert among us. Senator Harris is here, and I don't need to oversimplify or answer some of these questions in a way that I'm sure she has great insight. So I would also defer to her.
Thank you. And I will call on Senator Harris next. I guess the thing I wanted to clarify was whether or not the intention or the result of that language would be that somebody who might be in a less formal arrangement, if someone is taking care of a family member's or neighbors or a friend's children or child for an extended period of time, but never enter into a formal guardianship arrangement, would they be covered under this statute? If they came to the state and said, you know, I've had this child with me for the last 4 months, I need to enroll him in school now, but I've never had never formally been appointed his guardian.
It would certainly apply to them. In those circumstances, though, Chair, I would tell you that Judge Schreiner and I have access to some investigative tools through our investigators. And so that scenario would cause me pause, and I would certainly ask for more information because that would be unique, that a non-parent without a court order would have in their care and custody for a period of months a child without any oversight or direction from the court. So I want to make sure kids are in school, but I also need to ensure that they're safe. So there would be some additional follow-up, but yes, it would include that type of scenario.
Great, that answers my question. And I see that Senator Harris has a question or maybe some information to share with us. So Senator Harris.
Thank you, Chair Scheibel. I actually had a similar question about that definition of home state. And from the discussion that we just had, I just want to clarify that I got my answer correctly. Are we switching was physically present to lived with a parent or a person acting as a parent in order to conform with the uniform law? Is that really the main purpose of changing that language, or is there another motivation there?
Judge Markey, I don't know if you have an answer to that.
I don't have a great answer, but I'm happy to follow up and get you all an answer. Our intention would be to conform with the UCCJEA, so because it applies to all of the states, so that it is much more clear. Sometimes a child can be physically present in a state without a person acting as their parent. So we would want, I think that's the distinction that the UCCJEA makes in this context. So if a person has brought a child here unlawfully, they are not acting as a parent, and so it would exclude that.
Thank you.
All right, if that's all from Senator Harris, I believe Senator Pickard has a question. Go ahead, Senator Pickard.
Thank you, Madam Chair. I appreciate it. And Judges Schreiner and Markey, it's great to see both of you again. You know, I wanted just to follow up a little bit. First, Judge Schreiner, you made the comment that we're mirroring the adult guardianships, and of course, with minor guardianships, we're also dealing with a fundamental parental right that we don't typically deal with in the adult guardianship arena. And it's on that basis, I wonder if you could expand a little bit on the shifting of the burden of proof in Section 2, sub B, where the objector is required to make the offer of proof that it's not in the best interest of the minor to be transferred. I understand from a practical standpoint, in the vast majority of these cases, we're going to have a parent who couldn't take care of the child for whatever reason, whether they were removed or not, or it was voluntary. And so we've got someone acting in a parental capacity who's been given that responsibility. Can you expand a little bit, explain why this shift is really appropriate?
Thank you, Senator Pickard. It's also nice to see you as well in a different format here. Certainly, and one thing I want to make clear, and I'm sure Judge Markey would if I did not, then in terms of minor guardianships, of course, they are very different than adult guardianships. Judge Markey handles both, and I only handle the minor guardianships, so she might be able to expand on that a little bit more. But in terms of the burden, certainly when you're dealing with a transfer of guardianship where we have the proof of a formal guardianship in another state, where there have been findings made already, I would say, to be a slightly colloquial, this is not an opportunity per se for a parent to have another bite at the apple, and we're going to have a whole new hearing again and put the child through that. But of course, we will have a hearing and hear any objection and see if they can meet that standard, because circumstances have changed. And Judge Markey, I don't know if you can expand on the difference between.
I would note that procedurally, let's take our same example from California. If a grandparent had a guardianship in California, that parent has already had notice and an opportunity to be heard, a right to appeal. All of those things have been offered. And then in California, the grandparent would request permission to relocate. Again, all of the family members would have been noticed, including the natural parent. There would have been a hearing, an opportunity to be heard, and a right to appeal that order, which is considered a final order. And then the person would move to Nevada and attempt to establish that Nevada guardianship. So we are taking full faith and credit that the guardianship order in California is valid. and should be enforced. We already have the permission of the court who's been overseeing that guardianship to come here. So it would be, again, give that natural parent absolutely notice of the citation and petition and an opportunity to be heard at the hearing. Should there be any real question at that time, and I understand that it could appear that it shifts the burden, but it actually gives them just another chance to be heard. And now this would be the third time that that parent has been heard, at least we know, relative to that guardianship, to discuss the issues, perhaps establish a better visitation schedule if geography has changed, and address some other issues. So I understand your concern, and certainly parents do have that fundamental right. But I would suggest that they have had the opportunity at 2 other occasions to contest the guardianship. There's always also an ongoing opportunity at any time for a natural parent or any other family member to petition to terminate the guardianship. And again, should my colleague or I be very concerned about the propriety of what's going on or the allegations at that time that are raised by the natural parent, we could certainly appoint an investigator, conduct an investigation, get additional information. We have a lot of things at our disposal to make sure that if there's an issue, we think that or any concern at that point in time, Senator Pickard, that we would have an opportunity to peruse that. So we're not starting from scratch with the guardianship. We're talking about when we transfer guardianship and a judge has already made a series of decisions, and that natural parent has had a notice and an opportunity to be heard about those decisions. Oh, Mr. Pickard, Senator Pickard, I think you're muted. I'm sorry.
No problem. Thank you. I clicked the button, but apparently it didn't work. That's where I thought you were going to go. And of course, when we're looking at these things, we're trying to look at the margins and see outside what the typical case would look like. You know, what are the potential unintended consequences if we don't think them through? So my thought was, what happens when we get a case, and I had one similar to this a couple of years ago, where someone had obtained a guardianship in another state without proper notice. And so now we had a parent trying to obtain custody of the child, and then found out that a month before a guardianship had been awarded. And so then we got into the jurisdictional question, and we had a UCCJEA conference, which I assume would occur if there were any kind of disputes of that regard. My only other question really is, how many cases are we talking about? You know, I don't remember seeing that many of the transfers that were ever objected to, but are we talking about something that's going to burden the district courts as we deal with this, or is this, can you tell me how many cases we're dealing with and how this affects the current calendars?
Thank you, Senator Pickard. I will address that first. For Washoe County, I would say we're really speaking of a handful, maybe a quarter. We don't have the population up here, but I would actually phrase it differently. By putting this mechanism in place, it actually will alleviate some of the burden, because at this point, these folks moving in here have to start again and apply for a whole new guardianship. But if we have the transfer mechanism, we have some background, they have things they're required to file, certified copies, that sort of thing. It's actually going to save time.
Senator Pickard, I would echo the judge's statements. I think it will save time for the court because it sets up a more clear procedure. I don't have the exact numbers, Senator, but I will tell you that probably from your own experience, you know that we have a lot of families moving in and out of our jurisdiction ordinarily. But during this past 9 months, I have seen certainly an uptick. And in these circumstances, it's especially different. And let me tell you why. Many times we have perhaps parents that pass away unexpectedly, and grandparents who may be living in Sun City here in a retirement community suddenly have the care and custody of their grandchildren. And when they chose Clark County as their place of residence, and when they chose their home, they didn't expect this tragedy. And so many times we see them moving back to be closer to family, so that they have cousins and brothers and sisters and other extended family to help them raise that child in an environment that maybe they lived in prior to their retirement. That's quite common. And certainly they have many reasons that they want to do that. And I know you see that in your practice in custody matters, maybe a job or other circumstances. But especially with grandparents, we see a relocation shortly after, in the months or a year after a guardianship has been granted. And it's a help to them because this procedure really spells out exactly what they need to do and how to handle it.
Thank you. I appreciate that answer. I would, just out of curiosity, if we have the statistics, I'd be interested to know how many cases we are dealing with, but we can take that offline. Thank you for those. And thank you, Madam Chair. Appreciate the opportunity.
Absolutely. And I understand that Senator Settlemyre also has a question. Go ahead, Senator.
Thank you. Thank you, Chair Scheibel. I was curious if this bill will help out in regards to a problem that I've seen in my community with situations of guardianships, where sadly in my community we have a fair amount of grandparents that are raising their grandchildren because sadly their children, usually drug, alcohol related, kind of forget they have children. And then after they sober up, then they want the child back. And then it ends up being a terrible thing for the child being pulled from one state, usually California, back to California or Nevada. How does that work? And does the bill help out with that, especially in relation? I mean, what happens if you're a grandparent, you go and you become guardian of a kid, but do they talk to the other state, to California, to say, hey, this person's now the guardian, or how does that all work? And does this bill help that problem?
I'm going to jump in real fast with the housekeeping matter. For the presenters who are answering questions, if you could just identify yourselves for the record before you start speaking so that our secretaries can get the notes right.
Thank you. And this is Judge Tamitha Schreinert. I do have to go in a few minutes, so I just thought I'd jump in before Judge Markey and answer that. That is a situation that we are seeing quite often, and it is very tragic for all involved, certainly. To answer part of your question, in a case like that where there's been a guardianship here in Nevada and now there's some movement to a different state, and we would absolutely have a conference with the court in that other state. We call it a UCC-JEA conference, and to determine the best jurisdiction. And if the child's been living here, then we would be able to keep that jurisdiction to make the decisions in the best interest. So that is part of the reason for the bill, to make sure we're conforming the statute with the UCC-JEA.
This is Senator Settlemyre. Thank you, Chair, and thank you, Judge, for that answer. I greatly appreciate it.
All right, and thank you everybody for your questions. I don't see any more hands raised either through the Zoom function or physically. So I will take that to mean that there are no more questions from the committee. Thank you for joining us, Judge Schreinert, and good luck in your trial. And with that, we will move on to testimony in support of SB 8. And for those of you who may be calling in to testify, I will also remind you that you need to identify yourself by name and provide the spelling of the name when you first start, and then your 2 minutes will begin.
Thank you, Chair. To testify in support of SB 8, please press *9 now to take your place in the queue. Once again, callers, to testify in support of SB 8, please press *9 now to take your place in the queue. Chair, there are no callers in line to voice their support at this time.
All right, then. We will move on to testimony in opposition to SB 8.
Thank you, Chair. To testify in opposition of Bill SB 8, please press *9 now to take your place in the queue. Once again, to testify in opposition of SB 8, please press *9 now to take your place in the queue. And Chair, at this time, there is no caller looking to voice their opposition to SB 8.
All right. Then we will move on to testimony in the neutral position on SB 8.
Thank you, Chair. To testify in neutrality on SB 8, please press *9 now to take your place in the queue. Once again, callers, to testify in neutral stance on SB 8, please press *9 now to take your place in the queue.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. Stephen with a V. Cohen, C-O-H-E-N, as in the Assemblywoman, but no known relation. So I'd like to propose an amendment that may answer one of the earlier questions that was posed. And I have it in front of me and will submit it to staff afterwards. But it's going to address a related subject of supported decision making, which is NRS 162C, like Charles, sub 200 if we do nothing else to it. So one of the issues that's come up specifically during COVID is when this was conceived in the 19 session, supported decision making as an alternative to guardianship for adults in particular, it required in-person signatures with witnesses. Unfortunately, that is not, with the COVID restrictions, really a feasible option at this point. So it would kind of, as the courts have mostly done, would permit essentially electronic signatures and kind of defer to the emergency statutes in situations like this, and we could put a time limit on it if we wanted to. That's something we could work out in negotiating it. But like I said, it's kind of put a damper on folks being able to implement that less restrictive option to guardianship for adults in particular, is my understanding. And with that, thank you, Madam Chair, and I yield.
Thank you, caller. And with that, Chair, there are no more callers in neutral standing at this time.
Okay, seeing as there is no one else here to testify on SB 8, I will now close the hearing on SB 8, and I will open the hearing on SB 7. I believe we have Judge Zaragoza with us to present that bill.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. I'm going to give a brief introduction and then turn it over to John McCormick to go through the bill further. I'm Judge Melissa Zaragoza. I am the Chief Judge of the Las Vegas Justice Court. This bill is in relation to the jurisdictional authority for a temporary protective order that names an adverse party that is a juvenile. The justice courts of our state currently hear all types of protection order applications in our court, with the exception of protection against domestic violence and high-risk behavior, which are heard in the district court in counties exceeding 700,000 in population. Over the past 10 years, our court has heard an average of 1,836 cases per year, 1,826 in 2020. However, less than 10 of those cases fall into the category that we're talking about today, and that is where there's a juvenile as an adverse party. And usually those take the form of a protective order against stalking and harassment. An illustrative case from May of 2018, involved an application for protection against stalking and harassment against a middle school student who pushed another student and cracked her tooth. My court, the Las Vegas Justice Court, drafted a lengthy order with legal analysis and conclusions, and to transfer the case to the juvenile court, thinking that they should have proper jurisdiction, only to have the district court transfer the case right back to us for lack of jurisdiction, causing a delay in the action on the application and highlighting the problem that this bill today hopes to resolve. It's not the volume that presents a problem for our court, it's really the jurisdiction. So the justice courts have clearly subject matter jurisdiction to hear various types of protection order cases as outlined in NRS 4.370, which is part or section 2 of the bill. However, there's no clear jurisdiction over the person of the juvenile adverse party. Conversely, Chapter 62B of the Nevada Revised Statutes provides exclusive original jurisdiction over the juvenile and delinquency matters, but it does not clearly provide subject matter jurisdiction for protection orders. We hope that this bill will provide clear jurisdictional authority in our statutes, and we believe the Las Vegas Justice Court believes that these cases are really more appropriate for the juvenile courts to hear, given the adverse party's age. Should the Justice Court keep these cases, one of the problems is that we have no authority to even enforce our own order. The enforcement can take place in two methods. One, a separate criminal action, which as for an adult would be either a misdemeanor or gross misdemeanor. For a juvenile, that would be the initiation of a juvenile delinquency matter, neither of which would happen for a juvenile in our court or the justice courts. The other method is contempt of court, and there is no statutory authority that makes it clear that a justice court can hold a contempt hearing and potentially hold a juvenile in contempt and subject to jail time for a juvenile. And that really kind of gives you the overview of what we're looking at in this particular bill. I would be happy to provide the written order that we prepared in that case, as it does have some legal analysis in it that might be of interest to you. And it also has a historical account of the creation of juvenile court systems overall. And I have no further comment. I'm happy to answer any questions, and I would turn it over to John McCormick with your permission.
Go ahead, Mr. McCormick.
Thank you, Chair. For the record, John McCormick. I'm the Assistant Court Administrator at the Supreme Court AOC. And in the spirit of full disclosure, just letting everyone know that Ben Graham is here with me, albeit off screen. Judge Zaragoza did a bang-up job indicating what the primary purpose of this bill is, and that is to give statutory guidance and statutory clarity on an area where none currently exists by granting that exclusive jurisdiction to the juvenile court to hear petitions for protection orders when the potential adverse party is in fact a juvenile. One thing we have seen, and Judge Zaragoza conveyed her experience in Clark County with Las Vegas Justice Court in the 8th, is that it's handled somewhat differently in other counties. So another goal of this bill is to make it uniform across the state and to bring clarity to that subject. So in the rare event where a protection order is sought against a juvenile, it would again bring that clarity. Also, currently in Justice Court, they have the statutory authority to issue what's called a protection order or an order for protection of minors or of children. However, that protection order can only be issued against an adult adverse party. So there's a gap sort of statutorily there that this would fix by allowing a specific process for protection orders against juveniles to be sought. To go quickly over the bill, Section 1 is the conference of jurisdiction to the juvenile court, the district court, for protection orders regarding domestic violence, stalking and harassment, high-risk behavior, sexual assault, and aggravate and stalking against juvenile adverse parties to the district court, the juvenile court there, harassment in the workplace is included as well. I'm sorry. The protection order type that's left out of the statute is that protection order on order for protection of minors, because that can't be issued against a juvenile, so it's not mentioned here. We were in discussions with the public defender's offices yesterday and cut sort of last minute, and I apologize for that. I submitted an amendment that removes subsection 2 from the original bill because there was concern about appointing counsel, and being that the court probably has the inherent authority to appoint counsel as necessary, we thought that didn't need to be addressed in this bill. Subsection 3 in the original language just indicates that the protection order has to be served against the juvenile who's the adverse party, as well as the parent or guardian of that child. Section 4 would have required the protection order be transmitted to the school at which the adverse party or the protected party attends. And in discussion with the public defenders, we thought that was probably not necessary in this case, so the amendment would remove that as well. Subsection 5 in the original bill just reiterates that the juvenile court has exclusive jurisdiction when a child is alleged to have violated the order, and that addresses the issue that Judge Zaragoza brought up about not being able to hold, justice courts not being able to hold the juvenile in contempt, etc. Subsection 6 in the original bill indicates that if a protection order is issued against a juvenile and they turn 18 during the time in which that order is effective, that order would remain effective until its expiration date or until the juvenile court dissolved that order. So it addresses what will certainly be a very small set of cases, if we're looking at 10 cases in the busiest jurisdiction in the state, where that age crossover from childhood to adulthood, for lack of a better way to put it, occurs. And also in subsection 7 of the original bill, it allows or it has the juvenile court automatically seal the records related to these matters when the adverse party reaches an age of 21. We have been discussing with the public defenders as well, and there may be some concern about that age. That age was copied sort of from some other sections in Chapter 62, but as I've indicated, we're more than happy to continue the discussions and open to amending as necessary. Section 2 of the bill is sort of the, for lack of a better term, cleanup section, where it makes clear that a justice court does not have jurisdiction in these protection order cases when the potential adverse party is a juvenile, and it adds that is appropriate throughout NRS 4.370, which is the justice court jurisdiction statute. And then Section 3 deals with sort of any protection orders that would fall in the gap between effective dates on the bills, to make sure that we don't leave somebody who had an order without an order. So that's sort of a quick overview of the bill. And again, the main goals here are to provide that statutory clarity and fill that gap to make it clear where, when, why, how a protection order is handled when the potential adverse party is juvenile. And it also makes it clear that protection orders in circumstances like this are available. For example, in the circumstance where, say, two 17-year-olds were in a dating relationship and there was an allegation of domestic violence, this would allow the victim there to request a protection order clearly through the juvenile court. So I think it fills a little gap there as well. So that's kind of the bill in a nutshell. As I've said, we're happy to continue to work with the public defenders. I'm sure they'll testify in opposition pursuant to the committee's rules. But we are happy to work with them as well as anyone else on this matter.
Thank you so much. I see a couple members of the committee have questions. I also have a question, so I'll go ahead and get mine out of the way first. And I'm wondering if, I was actually a little bit surprised to hear that there were only 10 of these cases last year. I had expected it to be more, but I do wonder if even in those 10, there would be any reason to keep the ability for the district court to obtain jurisdiction. And I'm thinking of two particular hypotheticals, and I'm looking to see if these are things that happen or not. One being if a juvenile is being charged as an adult in a criminal matter and the protection order being sought is pursuant to the same facts and circumstances as the criminal matter, would we want the protective order to be able to be heard by the district court? And the second kind of situation that I'm thinking of is where protection orders are sought between multiple parties, like two neighbors or two families that are in need of some distance. And so would we end up with mom and dad in district court and the 16-year-old neighbor in juvenile court and create an even messier situation than if they all just went up to the district court?
Chair Scheibel, excellent hypotheticals. I'm thinking in my head of kind of how those would work themselves out in our system. Before I even answer that, I want to make sure that I am honest and open with my comments when I said the 10. We don't have any method of data counting the exact number of those cases. So what I can tell you is this: I have canvassed my bench multiple times on this issue. We also had a related, differently structured bill last session, and the numbers have remained the same. I can't find judges on my bench who can identify more than 10 in any given year. Sometimes they can remember 6, but it's anecdotal because we don't keep track of that data point. And many times we'll get a stalking and harassment protective or application. When the parties come to court, the applicant doesn't know the date of birth. They might know a name of the individual, they might not know their age, and so they show up into court and you don't even know they're a juvenile until they walk in and you see them and you ask them their age. So it's not a hard number of 10, but that's a rough anecdotal amount. To respond to your questions, I think those are really, really excellent points in terms of if the underlying behavior is a result of a case. So for example, protection against sexual assault. It happens. We have a juvenile sexual assault division, and those cases do arise, and it's not uncommon in a serious situation where that juvenile may be tried as an adult. And again, the justice court being kind of in the middle of that whole thing, because ultimately that case is going to get tried before the district court if they are treated as an adult. And maybe again, the district court overall is the better fit for those scenarios that you talk about. The neighbor against neighbor, again, those protective orders are individual. They name an individual adverse party, not a family, as you put forth. I haven't seen a case like that. I've seen definite cases where there are neighbors that are bothered by the children of their neighbors and people throwing rocks and doing juvenile things. And I've definitely seen those. I've never seen one where there are adults charged in one case and juveniles in another. But that's not to say it hasn't happened. I think those are good nuggets of things to chew on and think about. And I think that might end up potentially restructuring section 1 of the bill, but I don't think it would impact section 2. I just don't think justice court's the place for it in the long run.
Okay, that answers my question because you have so much more experience with this than I do. So I appreciate you giving us that context. I am going to move next to Senator Harris.
Thank you, Chair Scheibel. I did not originally have a question until Mr. McCormick mentioned that they were going to be amending out section 2, and I guess I didn't quite understand why that amendment was being made. Could you run me back through the logic on that?
Thank you, Senator. For the record, John McCormick. In discussions with the public defender's offices, there was a concern about increasing a caseload, I believe, for them by requiring the appointment of counsel. And I believe that the offices were more, and they will have to speak to this a little bit more again. I think we're in process of working with them. I think an alternative. I think they would be more comfortable without the specific provision to appoint counsel. However, I think the court has that inherent authority to appoint counsel for a juvenile, certainly in a delinquency matter that's required in 62B030, I think. I could be wrong on that. I'm sure Nick could correct me. And so particularly the Clark County Public Defender's Office was more comfortable with that section being removed. I think in the event that a juvenile was alleged to have violated an order, then that would either be a contempt issue or be a delinquency issue where the child could face potential loss of liberty. So I think counsel would have to be appointed in that case. So that's kind of the story behind that. And hopefully Mr. Pirro from the Clark County Public Defender's Office to talk a little bit more about their concern with that section.
Okay, Mr. McCormick, maybe I'll have to, you're right, maybe have to bring this on to them, but it seems to me subsection 2 is already permissive. It doesn't require the appointment of counsel. And did I hear you correctly in saying that the court already has the authority to do what's in subsection 2 currently?
Again, I am not the arbiter of inherent powers of the court, but I think a strong argument, John McCormick for the record, I think an argument could be made that the court has the inherent authority to appoint counsel as they see it necessary, particularly in the juvenile arena. Honestly, how that ended up there is in drafting. We were looking at the statute from Ohio. Ohio kind of pioneered this, and they have a whole statutory scheme, and I borrowed very liberally from their statute in trying to come up sort of with this language, and that just kind of got transferred over, honestly.
Thank you.
All right, if that's it for you, Senator Harris, I believe Senator Pickard has a question.
Thank you, Madam Chair. And yes, you actually asked one of them, Madam Chair, and that was much better stated than I would have. So I appreciate you answering that one. My question, I remember when this came up like 3 or 4 years ago, and this was an access to justice issue, which is why we left it in the justice courts. But specifically, the first question I have regards the high-risk behavior, which 33550 really is about the behaviors tied to firearms, and where minors aren't legally owners of firearms, but there are probably firearms in the home. My concern is a practical one. If we end up with a situation where a minor now is without or is deemed to be engaging in some high-risk behavior, and there are firearms in the home, are we then requiring those to be confiscated from the home, ultimately then from people who are not implicated in the high-risk behavior order? How does that work on a practical level?
Thank you, Senator Pickard. For the record, John McCormick. Not to split hairs here, I think because there was no specific statutory prohibition against an order, a high-risk behavior protection order being issued against a juvenile, that as a practical matter, it was included in this bill. I think that would more be a policy question, perhaps for the legislative body to determine if that is the intent of those. The only protection order that was excluded in drafting, like I said, is the one that specifically statutorily cannot be issued against a minor. And again, I think that would, in practical sort of terms, if this were to, pass and be effective tomorrow in this form, I think that in the event that somebody petitioned for an order, high-risk behavior protection order, the court would have to analyze that and determine, because it was against the juvenile who can't legally own the firearms, if access to the firearms was an issue in that specific case. And one thing, this is somewhat related, kind of anecdotally, one thing we have seen since the implementation of the high-risk behavior protection orders is that the vast majority of those, and we'll actually talk more about this when another bill comes up that I won't mention so they don't have to put it in the minutes. But anecdotally, the vast majority of sort of family applications for high-risk behavior orders have actually been found to be more appropriate for one of the standard, for lack of a better term, protection orders, usually domestic violence or stalking and harassment. So again, that's just sort of another piece of information, but I think that that would be a policy question again for the legislature if you were to determine that because juveniles can't legally own firearms, you didn't want high-risk behavior orders for those persons. But
well, I appreciate that. I mean, my thought really was, do we muddy the water by naming them, since the high-risk protection order really was designed for only adults? And I think that's why the exclusion occurred. Not that it was a deliberate step to exclude juveniles, but it didn't apply to them because they don't own firearms. And in many respects, and I recall the presentation fairly well, that this was a means for family members to obtain the high-risk behavior order where they were potentially a threat to themselves. I won't belabor that point too much more. Let me just ask my final question, if I may, Madam Chair. And that's currently in Clark County anyway, most of the juvenile cases are heard by the juvenile hearing master or hearing masters. And are we maintaining that, since we're taking this away from the justice courts, are we maintaining the juvenile hearing masters in their ability to hear these cases, or are all of these cases going to be routed to our one juvenile district court judge?
For the record, again, John McCormick, Senator Pickard, this bill does not touch on that. It doesn't amend the existing statutory provisions. They allow the appointment of masters. So I believe masters would obviously be able to hear these matters practically. And I think that also raises a good point. In some rural communities, and that may be where an access to justice concern comes up, the justices of the peace locally have been appointed as a juvenile master to provide juvenile court in the local community. So this would actually allow practically for the same court to be applied to for the order, but it would be done under the auspices of the juvenile court. So again, there's no intention in this bill to prohibit a master from doing that. And I think broadly, particularly in family court jurisdictions like Clark and Washoe counties, because the district court is the juvenile court, I think there's some leeway there for the presiding or chief judge to make some determinations about who would hear these types of applications as well.
Very good. And yes, you spoke directly to what I was talking about with the access to justice issue in the rural areas. The JPs are hearing these cases, hearing the juvenile cases typically. So good. I appreciate your responses. Thank you, Madam Chair.
Absolutely. And it looks like we have two more senators with questions. I will go first to Senator Orenshaw.
Thank you, Chair. I have two questions, if the chair will indulge me. On section 1, I believe we're at sub 3. In terms of the notification to schools, as I understand it, currently school notification, happens with just some of the most serious, juvenile sex offense adjudications. So I'm just kind of wondering, with this, I'm just a little worried about notifying if one of these orders exists, with school notification, what effect it might have on, on the child attending. I'm a little concerned about that. And I don't know if that's based on the Ohio legislation or where that comes from, but that seems like a big leap from current Nevada law with kids who've been adjudicated delinquent for those serious sexual offenses only. And then in terms of the record sealing with, I heard there was testimony about trying to possibly move that, but setting it at 21 concerns me because currently I think under NRS 62H130, if a child's adjudicated delinquent, they're potentially eligible to have their juvenile record sealed even younger than 18. So I'm kind of concerned about pushing this up when, it may not be, it certainly doesn't match what current law is on delinquent offenses.
Senator Orenthal, if I may, this is Judge Zaragoza. The point that you touched on originally about the reporting it to the school, that was the issue that I discussed with John Pirro of the Clark County Public Defender's Office yesterday, and Kendra Birchie, I believe you pronounce her last name, from the Washoe Public Defender's Office. We had a conference call yesterday and talked about a couple of these issues. And that is, one, I don't think the court wants to be in the position of having the burden of hunting down which schools are applicable to serve those documents. And two, we concurred after discussion to remove that section. So the amendment that John McCormick has prepared does amend that section to delete those school reporting requirements. Now, that's not to say that an applicant who is successful and obtains a protective order can't go and take it to the school, but that won't be coming from the court and it would not be a mandatory report. The second issue with respect to the age of sealing was another issue that we touched upon in our conversation yesterday, and we're completely open to any amendment with respect to that. It doesn't appear to me to be any issue to seal that upon expiration. If there's no application to extend it further, there would be no reason not to seal it upon expiration. And I have no issue with any sort of amendment along those lines.
And sorry if I may, Chair John McCormick for the record. And I will own the school reporting. I stole that from Ohio. So in retrospect, it's probably not right for Nevada. And then also what in drafting where it references 62H140 in the record sealing, that is when the record is mandatorily sealed at 21. So that was the idea here, at least in my thinking, is that these are mandatorily sealed at 21. However, I think what we could do amendatorily, if that's a word, if not, I'm making it up, is include a reference to 62H130 here that a juvenile adverse party could move prior to age 21 to seal the record.
Thank you, Mr. McCormick. Thank you, Chair.
All right, if that covers your questions, I will move on to Senator Harris.
Thank you, Chair Scheibel, for allowing me to ask the second question. I apologize to the committee for not having them all together on the first round. I've noticed that NRS 33.400 is excluded from Section 1, subsection 1. I've been informed that this is actually a common way that protection orders against juveniles are brought. Is it your intention to have those not be under the jurisdiction of the juvenile court, or was that an oversight? Can you tell me a little bit about why that's not included?
Senator Harris, this is Judge Zaragoza. I can address that issue. No, it was not an oversight and not any intention to exclude them. NRS 33.400 is the provision of law that allows for a petition on behalf of a child. So we refer to them as a protection of minor protective order. In that statute that is in existence, it specifically says that the parent or guardian of a child may petition any court of competent jurisdiction on behalf of the child for a temporary or extended order against a person who is 18 years of age or older. That's the current language in that particular provision. which is why it was intentionally, I guess, left out of the juvenile provision, because the language speaks clearly that you can't get one of those against a juvenile. I don't know why. That is the only protective order statute that has that sort of age restriction, which was unusual, and I'm not sure the legislative history behind that, but that was the reason that it was excluded from this particular bill.
Okay, and so let me just make sure I understand. It is your contention that those that section cannot be used to bring a protection order against a minor?
Yes, that is my understanding of the way that statute is written.
Thank you.
So that raises a follow-up question for me. Basically, I understand 33.400 to be the statute that allows a parent to get a protective order against an adult on behalf of their child, for lack of a better term. Would this bill allow a parent to also get a protective order on behalf of their child against another minor?
For the record, John McCormick, Chair, I believe that would theoretically be permissible under here. I don't know that we specifically address the parent on applying on behalf of the minor, but the bill as proposed only addresses the adverse party, not necessarily the protected party. So I think if that was a concern, you could have a provision allowing for that. But I guess, so there would have to be some legal analysis on whether or not the parent could apply for the order on behalf of the child with the juvenile court against the juvenile adverse party. Our concern, I think, here was the adverse party, not necessarily the potential or the protected party.
Chair Scheibel, may I?
Please.
Judge Zaragoza, I think one of the issues is the judiciary is always very cautious of stepping on the legislative toes, if you will, and it's not our intent to create policy. So what we were trying to present before you was a manner of providing clarity of the jurisdiction over the adverse party. And by all means, I hear you loud and clear, and not from a judicial hat, but from a parent hat. I agree that a parent many times is the appropriate person to kind of step in on behalf of their child to seek a protective order. And if it is against an adult, in the justice court or district court where appropriate, against a juvenile in the juvenile court. But we didn't take that liberty out of respect because we were trying to clean up a jurisdictional issue and not create policy. But we're happy for any amendments along those lines at your discretion.
All right, I think that answers my question. Are there any other questions from the committee? I am not seeing any other questions. So thank you so much for your presentation. We will move on now to testimony in support of SB 7.
Thank you, Chair. To testify in support of SB 7, please press *9 now to enter the queue. Again, to testify in support on SB Bill 9 now, please press *9 to enter the queue. Will the caller with the last 3 digits 028 please slowly state and spell your name for the record? You have 2 minutes. You may now begin.
Thank you. My name is Judge Bridget Robb. I am, and the name is spelled BRIDGET-ROBB. I am a district judge with the 2nd Judicial District Court, the immediate past presiding judge of the family division of that court, and currently the delinquency business unit presiding judge for that court. And I and my colleagues are in favor of SB 7 for the exact reasons that have already been stated by Judge Zaragoza, that we believe that there was a jurisdictional issue and the district court is in a better position already having the juvenile court to be able to deal with the TPO issues involving juveniles. If I can very briefly answer, in addition, some of the questions that were asked by both the chair and senators. Chair Scheibel, you had asked a question with regard to serious cases involving things such as sexual assault. And I can tell you, having presided over those cases, that there is almost always an order, even if there isn't a TPO requested, there is almost always an order that the juvenile stay away from the victim in any event. So that is already taking place in juvenile court. And for Senator Pickard, I agree with you regarding the access to justice. One of the considerations for our bench was the fact that this will clarify where an applicant is to file their TPO application, as opposed to having to pick and choose. Right now, if it's domestic violence, it goes to the district court whether it's a juvenile or not. If it's other types of, for example, stalking and harassment, those type of protective order applications would be filed in justice court. This is going to make it easier, I believe, for the applicant, because you're not going to have to make that choice. If it involves a juvenile, it will be filed with the district court. If there is anything else that I can answer, I would be more than happy to do so.
Thank you, Judge Robb, for your testimony. It doesn't look like there are any questions, but I would encourage senators to follow up offline with Judge Robb if you would like. And we will move on to the next person in support.
Chair, there are no more callers in support at this time.
All right, then we will move on to callers in opposition.
Thank you, Chair. To testify in opposition on SB 7, please press star 9 now to enter the queue. Again, to testify in opposition on SB 7, please press star 9 now to enter the queue. Will the caller with the last 3 digits, 611, please slowly state and spell your name for the record? You have 2 minutes. You may now begin. Will the caller with the last 3 digits, 611, please slowly state and spell your name for the record? You have 2 minutes. You may now begin.
Good afternoon. This is John Piro, Johnpiro from the Clark County Public Defender's Office. I'd like to first start by saying that we fully agree that TPOs and extended protection orders involving juveniles should be handled in juvenile court as opposed to justice court. However, at this time, pursuant to committee rules, we have to oppose the bill. But as Mr. McCormick and Judge Saragosa have stated, we have a good working relationship with them, and we believe that we'll be able to work this situation out and move us out of the opposition position. First, I'd like to say that one of our first issues was Section 1, Subsection 2 with appointment of counsel, and I want to address Senator Harris's concerns. As Judge Saragosa said, they do not have the exact numbers. They think it's 10 cases. It could be 10 cases. But currently, in 2019, our juvenile attorneys, and we only have 11 of them right now, handled 2,979 cases. That's 270 cases per attorney. In 2020, it was a little bit different because of the pandemic. They handled 1,732 cases between 11 attorneys, and that was 157 cases per attorney. So adding any more workload without increasing a body in that office is a concern for our office and may trigger us to run the numbers and perhaps put a fiscal note on the bill. That's why the goal was to remove Section 2. Even though the court does have discretion to do that, it has been our experience, and no disrespect to the judges, that when the judge has the option to appoint, they do appoint. Our second concern was with Section 1, Subsection 4, notification to the kids' schools, and Senator Orenshall hit on our concern. with that as well, but Mr. McCormick said they are willing to remove that. We don't want notification to the kid's school to be used as a way to remove a kid from school and therefore exacerbate the problem with the school to prison pipeline, especially if it's something as simple as a fight between students. And again, we're in talks with the sponsor and perhaps we would fix that. Our next concern is section 1 sub 7, which allows for the automatic record sealing. And as Mr. McCormick said, we can fix that as well. And lastly, section 1 sub 5 with the contempt of court. So those are our concerns with the bill, and we're hoping that we'll be able to work this out and move us out of the opposition position.
Thank you. Will the caller with the last 3 digits, 318, please slowly spell and state your name for the record? You have 2 minutes. You may now begin.
Good afternoon. This is Kendra Birchie, Kendra, Birchie, Bertschy. And for the record, I'm the lobbyist for the Washoe County Public Defender's Office. Good afternoon, Chair Scheibel and members of the Senate Judiciary. I first want to thank the bill sponsors, especially Judge Robb, Judge Zaragoza, and Mr. McCormick for speaking with myself as well as Mr. Pirro yesterday regarding this bill. We appreciate their willingness to meet with us, consider our concerns, as well as commit to continue to work with us to address these issues. As Mr. Pirro indicated, we are testifying in opposition today, but do hope to be able to come to a different position based off of addressing our concerns. We do appreciate the sponsors working with us so quickly to remove the school reporting requirement. As Mr. Pirro indicated, an overarching policy concern that we need to make sure that we are addressing with this bill is the goal to ensure that we are not enacting law that will perpetuate the school to prison pipeline. This bill will put juveniles who will not already be involved in the juvenile delinquency system under the juvenile court's jurisdiction and potential supervision. With that in mind, my office differs from Mr. Pirro's office in that we believe it is critical to mandate that attorneys are appointed to these cases as soon as possible so that we can help ensure that juveniles understand the expectations, understand the order, and have someone advocating in court on their behalf. So regarding section 1, subsection 2 of the bill, we strongly believe that there needs to be that mandate that a counsel is appointed. We believe that that needs to be done at the issuance of the TPO or upon a setting of any hearing regarding this issue. As indicated by the sponsor, we're in the difficult position because we don't have data as to how many cases this will have, how this will increase our workload. But even with that in mind, we believe that because of the consequences of these issues and these orders and potential of what happens if an order is violated, due to the significance, it justifies the mandate of having an attorney. As Mr. Pirro indicated, our other concern was specifically regarding section 1, subsection 7. I believe that I heard Judge Zaragoza indicate that she would be in favor of allowing automatic sealing upon the expiration of the order. We would be in favor of that, just because with this bill, it indicates that not all juveniles may have been previously under delinquency cases. So we want to make sure that there is a mandatory sealing process and it occurs prior to 21. Additionally, NRS 33.560 sets forth a process that it would allow an adverse party to request information to be removed from the central repository. And so we want to make sure that that would be applied in these cases. For example, if the court decided that they did not have the ability to extend a protective order, we want to make sure that that provision is set forth as well. The additional concern that we have is just with the process in terms of how service is effectuated on these children. For example, we want to make sure that no one believes it's appropriate to serve and to have an officer go to a minor child's school and serve them at school. We look forward to the continued conversations to ensure that we adequately protect our children and don't put any legislation that unintentionally causes harm. Thank you.
Thank you. Chair, there are no more callers in opposition at this time.
Thank you. And do we have any, then we will move on to neutral testimony. Do we have anybody here to testify in neutral?
Thank you, Chair. To testify in neutral on Bill SB 7, please press star 9 now to enter the queue. Again, to testify in neutral on Bill SB 7, please press star 9 now to enter the queue. Chair, there are no more callers in off neutral at this time.
All right then, thank you so much for your help. Seeing no further testimony, we will close the hearing on SB 7. I would like to ask, however, that the sponsors of the bill, we would like to take you up on your offer to provide us with the order that you mentioned from the May 2018 case that was utilized to explore these jurisdictional issues. And with that, we will move on to our next and what I believe is our last item on the agenda, which is public comment. I would like to remind everybody who wants to make a public comment that they are limited to 2 minutes, but they can always submit additional comments in writing. And at this time, I will ask our fantastic staff at BPS to open up the phone lines for public comment. Oh, and also state your name and spell it for the record when you get on the phone.
Thank you, Chair. To testify in public comment, please press star 9 now to enter the queue. Chair, it looks like there are no new callers at this time.
All right then, unless there's anything from any members of the committee, doesn't look like it, then that concludes our agenda for today. We will be adjourned until 1 p.m. on Monday. And have a great weekend, everybody.